Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
And today our guest on Ask the Expert is Anthony Clark with Anthony Clark and Associates out of Phoenix. Anthony is an attorney and debt counselor in the Valley of the Sun. Anthony, how you doing today?
Oh, pretty good. Waiting for the heat to come on over here.
Yeah, it's just going to start here pretty soon, beginning of May, as we're speaking. Hey, Anthony, tell me a little bit about yourself and your firm.
Well, I graduated from law school in 1993, and I've been practicing law steadily since then. I've been here in Phoenix since 1997. I would say probably 90% of what I do, 95% of what I do is bankruptcy in the bankruptcy field, and representing almost exclusively debtors in bankruptcy, individuals, professionals, and companies in that field.
Okay, now tell me, what is bankruptcy? Because I know there's like Chapter 7, 11, 13. Tell me about that.
Well, the etymology of the word is pretty revelatory. Bankruptcy in Spanish is bancarrota, which the old Latin was broken bench, and the idea was when a merchant in the marketplace could not pay his or her debts, other merchants would come around and break up his bench and take all of what was left, and then he would be absolved of future debt. But then through the common law in England and other places, we saw at one point in our history a time when people could be jailed for failing to pay their debts. Even in this country, there were what they called debtors' prisons, and it was sort of a quasi-criminal state to be in at that time. And you served your time, and then you got discharged from debtor's prison, and that word continues in the parlance of bankruptcy. That's kind of what you're going for, is to obtain a discharge. And bankruptcy cases, if you do everything that you're required to do, result in a discharge. If you're eligible and you fulfill the requirements, you get a discharge of debt. And a discharge is essentially an order of the United States District Court, where you've filed the bankruptcy case, that says that certain debts are going to be eliminated forever. In essence, it's an injunctive order. It's a commandment to creditors that they must not attempt to collect those certain debts that have been discharged in the proceeding. They must never come back to bother the debtor, call the debtor, write the debtor, sue the debtor, or take any action against the debtor to collect these certain debts that are discharged in the process. There are several flavors of bankruptcy. The most common is Chapter 7. It's probably 85% of all bankruptcy cases. I think there are something like 2 million bankruptcy cases filed every year, something on that order. And the vast majority of them are Chapter 7 cases. You can only file a Chapter 7 once every 8 years, so it's a very valuable legal privilege to go through Chapter 7 and discharge all of your dischargeable debts. And certainly I consult with, I'll say maybe one person a week that I tell them, you're giving up your once every 8-year privilege for not a lot of relief. And I, in essence, talk those people out of filing a bankruptcy case frequently. But the debts that are not dischargeable, certain taxes are not dischargeable. A lot of people don't know that taxes are dischargeable at all, but yes, they are if they meet very specific criteria. Student loans, not dischargeable in bankruptcy unless you sue during the bankruptcy proceeding and establish that you suffer under a set of circumstances that amounts to an undue hardship. And there's lots we could talk about that. So certain taxes, student loans, back child support and alimony, not dischargeable in bankruptcy. Debts that arise out of a divorce or separation agreement are not dischargeable in Chapter 7, but may be dischargeable in Chapter 11 or Chapter 13. Debts incurred by fraud. If you, for example, the most common example of this scenario is when one gives false financial information to a lender in order to bolster their application for credit. If you then declare bankruptcy, the creditor the creditor has the option of filing an action in bankruptcy court to deny you a discharge of that debt. And that's incurred by larceny. I mean, if you rob a bank and they catch you, you can't just declare bankruptcy and keep the money. That doesn't work that way. Debts incurred while driving drunk. That's for personal injury that you caused to somebody because you were driving drunk or impaired, not dischargeable. And debts arising out of willful or malicious conduct. You know, if you push someone down the stairs and you break their neck and they sue you for $1 million, you can't just declare bankruptcy and walk away from that. But virtually everything else is dischargeable. And Chapter 7, like I say, is the most common proceeding in bankruptcy. It's probably 85% or more of all bankruptcy cases. If you know someone who went through a bankruptcy, it was probably a Chapter 7. And if you owe a creditor in connection with specific property, for example, a mortgage or an automobile loan or a furniture or jewelry loan, those creditors have rights in that property. They have established sort of like ownership rights. You can consider your mortgage company sort of a co-owner with you, or your automobile lender's a co-owner with you on the property. And after Chapter 7, if you want to keep the property, then certainly you'll have to continue paying them to satisfy the underlying loan, so that you discharge their rights in the property, else they would take it back. And sometimes people, I think it's a little bit surprising that they don't understand that when they start talking about a bankruptcy case. Some folks get the idea that they could file a bankruptcy and not pay their car payment and keep the car, or not pay the mortgage and keep the house. But if that were the case, then there would be no mortgage lenders and there would be no car lenders, because no one would foolishly advance tens of thousands or hundreds of thousands of dollars to someone just to have them keep the collateral after a bankruptcy filing. So after Chapter 7, you definitely got to continue paying. The bankruptcy chapters break down into sort of two camps. Chapter 7, which is what's called a liquidation bankruptcy, and then the reorganization bankruptcies, which are the others. In Chapter 7, you eliminate all of your dischargeable debt, and we've identified, the categories of debts that are not dischargeable that you still owe afterwards. And in exchange for eliminating all your debt, you give up all your property except what is protected under state or federal law. Every state has a set of statutes that are in effect within the state that protect certain property from creditors. And the idea is that, if you didn't have some level of protection, then creditors could make wards of the state of debtors who, fell on hard times or lost their job or got sick or got hurt or got divorced. And so every state has some scheme to protect certain basic property, and it does vary somewhat widely from state to state. And then there is as well a set of federal exemptions. These are called, these laws that protect certain property are called exemptions. There's a set of federal exemptions, but they're not available in every state. For example, here in Arizona, they are not available to residents, the federal exemptions, but Arizona has a robust set of exemptions that include, for example, a $150,000 homestead exemption. So what that means, translating that, if you file Chapter 7, you could own your house free and clear, not owe any money on it, and if it's not worth more than $150,000, you can keep it. But if you own such a house and you also own a vacation lot up in Show Low or Pine, somewhere up north around Flagstaff or something, that would not be exempt. That would not be protected. And a court-appointed official called the trustee, who represents the interest of creditors, would have the right to sell that additional property, turn it into cash, liquidate it, and pay creditors. So there's two basic camps. Chapter 7, which is liquidate everything that's not protected to pay your creditors and eliminate all of your dischargeable debt. And then there's the reorganization bankruptcies. The reorganization bankruptcies actually give you a substantial number of ways to deal with your creditors, and it involves proposing a plan where you say, well, I can't pay the debts as they come due in the ordinary course of business, but here's what I can do. And if the plan meets the requirements under the bankruptcy code, then you can adjust the rights of creditors, including secured creditors, creditors who have a lien on some property that you own. You can, for example, a very attractive facet of reorganization bankruptcies is you can cram down a secured creditor. That is, if you owe, for example, $20,000 on an automobile, but the automobile is only worth $10,000, then you may propose a plan where you'll pay just $10,000 for the automobile, and you'll pay an interest rate that is tied very closely to the prime rate. You might be paying maybe 4 or 5% interest, whereas outside bankruptcy you might have an automobile loan that has a 15% interest rate or something like that. And the reorganization bankruptcies also deal very handily with taxes that you can't eliminate in Chapter 7 liquidation. You can stop the interest from accruing, the interest and penalty, and propose to pay just the principal amount of the tax plus the interest that's been accrued through the date you file the case. So those are the basic differences. And like I say, Chapter 7 is the most common proceeding. It's probably 85%. And some of that has to do with the fact that it's very brief and relatively simple. And most people don't lose any property in Chapter 7 through that liquidation mechanism, mostly because they don't have very much.
Right.
And what they have is exempt. It's protected under state or federal law.
This is great information, Anthony. Now, what should we look for in a bankruptcy lawyer?
Well, in the legal profession, bankruptcy lawyers are sometimes, I've seen bankruptcy lawyers portrayed in media sometimes as sort of like the Special Olympics of law or something. But actually, bankruptcy is, I would say, second to tax and patent law, third to tax and patent law, is probably one of the most complex and statutorily Byzantine processes that lawyers have to navigate, and consequently, not many people, not many lawyers, are willing to undertake a bankruptcy case unless it's their daily bread. If it's not something they do every day, they don't want to get involved, because it is very complex, and it's also evolving, like all areas of law. But most recently, in 2005, that was the latest major reform in bankruptcy law, and it was very significant and very complex. So if your financial affairs are exceedingly simple, then you can probably get through a bankruptcy with a lawyer that does not necessarily have a great deal of experience in the process. However, if your affairs are not exceedingly simple, then mistakes can be made by someone who doesn't do this on a daily basis and is not plugged into the changes in the law and the developments with the statute. And you can have some significant prejudice if you don't get someone who has experience and dedicates a major portion of what they do to this area of law. So I would say you want somebody with experience. particularly if you have two nickels to rub together, if you have property you don't want to lose, if you're going to tend toward a reorganization bankruptcy where you have things you want to retain and you need a plan of reorganization. That's a long-term proposition. Chapter 13, for example, has a 5-year, 60-month maximum duration, and I've been doing it since 1994, and there are things that are changing every day. The forms that are filed in bankruptcy cases are drawn by the Federal Judicial Conference, and they change on something of a regular basis. They changed in December in very significant ways. And so, like I say, if you don't at least consult with an attorney who does bankruptcy every day, there's a good chance that you'll have some bumps and scrapes, particularly if you have somewhat complex financial affairs. If you own real estate and automobiles and things of that nature, if you don't have the benefit of an experienced practitioner, you could get some unwelcome surprises. So I would say experience, and just as dealing with any lawyer, if they have a lot of bar complaints or rip-off reports, then you probably want to check with another lawyer.
That's a good point. Well, and I noticed on your website, answersaboutbankruptcy.com. Well, two things I noticed: a lot of good information on your website. The other thing I noticed is you've got offices all over the Phoenix area. So, what's the best way to get in touch with you?
Well, today, in this day and age, we are now more than ever before capable of rendering legal services, particularly in the field of bankruptcy. I'll say that probably lends itself to a virtual office setting more than maybe any other area, because the whole practice of bankruptcy is about names, addresses, numbers, and dates. And you can certainly do that just as well as you and I are talking here between Phoenix and Nebraska. And I'm conveying a lot of information. You're conveying information to me. And we could exchange anything we needed to by the Internet. We could exchange tax returns and credit data and pay stubs and bank statements, all of which are relevant in bankruptcy cases. So, yes, I've got many locations that are available to me should I need to meet with a client who does not have access to the Internet or does not have access to a printer or scanner. But as much as possible, we're doing everything we can virtually. There is one meeting that you have to attend in every bankruptcy case. There's one public meeting you have to attend in every bankruptcy case. It's called the Meeting of Creditors. It comes about 6 weeks after the case is filed. They should call it the Meeting of No Creditors, because creditors don't go typically. They don't have to go. Creditors don't lose anything if they don't go. They don't really gain anything by going, and so consequently they don't go. It's not a juridical moment. There's no decisions made at this meeting, but every debtor in bankruptcy is obliged to go to that meeting to give creditors an opportunity if they wanted to ask some questions. But moreover, it's about proving your identity. You got to have your driver's license and Social Security card when you go to the meeting, and then the trustee that's been appointed by the court to represent your creditors will take your oath on your papers. We'll ask you, have you made full and fair disclosures in your papers? Have you disclosed all of your assets? Have you identified all of your creditors? Is everything in your papers true and correct? And the meeting of creditors, there's typically 8 or 10 of them in a 30-minute segment for that trustee, from starting at about 8:30 or 9 o'clock in the morning until they're done for the day. So, I mean, do the math. If they're trying to do 8 or 10 every 30 minutes, that's about 3 minutes to confirm the identity and take your oath on your papers. And yes, creditors have the right to appear and ask you questions, but the trustee doesn't really have a whole lot of time in most instances for that. And my experience, which is pretty substantial, has been that the people who are most likely to appear at the meeting of creditors have X in front of their name. Ex-business partner, ex-boyfriend, ex-girlfriend, ex-mother-in-law. Ex-mother-in-law is a good one because that's someone who has some financial connection to you, so they've been identified as a creditor, but they have some need to confront you somewhere, and the trustee just doesn't have time for that because it's not going to lead to anything beneficial for the bankruptcy estate or for creditors, and so they typically shut that down after a couple minutes.
Well, Anthony, so the takeaway is you're easy to reach, and it can be done virtually or in person. If you want to reach Anthony, I always call it the Google business card. Just Google Attorney Anthony Clark, Phoenix, Arizona, and that's the best way to do it. Also, your phone number, if I can give that out, is 602-790-4959. And your website, answersaboutbankruptcy.com, with a lot of great information. And our guest today on Ask the Expert has been Anthony Clark, bankruptcy attorney and debt counselor in Phoenix, Arizona. Anthony, thanks for being on Ask the Expert today.
Thank you, Steve. It was a pleasure.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.